I'm not a lawyer, but this is part 2 of the state of Florida versus Calvin Riley Sr., aka the case of the officer opening a bottle of liquor, pouring the contents of that bottle out, and then putting the bottle back in the man's car. This is part 2. Okay, so jurors are selected and the trial begins. The state does their opening statement first and makes clear to the jury what the charges in this case are and what they intend to prove about those charges.
So first, driving under the influence. There's two things that the state must prove. That the defendant drove or he was in actual physical control of a vehicle. The second element that we must prove to you today is that while driving or in actual physical control of a vehicle, the defendant was under the influence of alcoholic beverages to the extent that his normal faculties were impaired. See, you're going to learn throughout today's trial that impairment isn't necessarily falling on the floor drunk. It can be something as simple as your vision is affected when I take my glasses off.
And then the state goes into the charge for driving with a suspended license.
The second charge in today's case is that the defendant was driving with a suspended or revoked license. Now, this charge has 3 different elements that we have to prove to you here today. The first element is that the defendant drove a motor vehicle upon a highway in this state. Number 2, that at the time he was operating his vehicle, his license was suspended. Third, we have to prove that at the time the defendant knew that his license was suspended.
State attorney goes on to say that Calvin was placed under arrest for a DUI before the officers even got to search his car. So that bottle and what Officer Oliver did actually has no bearing on his DUI charge.
You're going to learn that the defendant told Officer Muth 2 things. First, that he was drinking alcohol. I believe he said that he had 2 beers that night. Number 2, you're going to learn that the defendant told her where he was coming from that night. It's as simple as the defendant was at Pockets Bar and Grill earlier that night. He spent the night there drinking alcohol, and then he decided to get in his car and leave. You're going to learn that there was more than just a DUI investigation at that point. That they also decided to pull up their internal program, run a driver's license check on them, just like any other traffic stop that occurs. And when they did that, they noticed that the defendant's license was listed as suspended. So when Officer Oliver and Officer Muth see this, you're going to learn that they go and place him under arrest. And that's where the next part starts.
Now, on the flip side of that, the defense tells a different story in their opening.
Calvin Riley is innocent. This case involves an officer planting evidence. It is not an innocent mistake. Officer Kirsten Oliver of the Tallahassee Police Department stopped Mr. Riley for his headlights being out. She claims she smells marijuana. The claim that she smells marijuana is what lets her search the vehicle. They of course find no marijuana. Not one bit. However, it is what she does next that is truly shocking. Officer Oliver grabbed a full, sealed, unopened bottle of liquor. She then pours out some, but not all of the liquid, and then tosses the bottle back into his vehicle. She then lies and tells the officers that she found an open bottle. You will learn that officers claim to initially have arrested Mr. Riley for driving while license suspended or revoked, and not DUI, because they didn't have probable cause for DUI when they arrested him.
The defense says that the cops were initially trying to use them saying that they smell weed as the reason for the DUI charge, but when they searched the car and didn't come up with any weed, they then tried to change it to say that Calvin was drunk. And the bottle that Officer Oliver found was used as a way to substantiate the DUI charge, and that's clear because it was mentioned in the police report. If the bottle didn't matter, then it should have never been mentioned in the report. And in regards to knowing about the suspended license,
the judge will instruct you that the state must prove Mr. Riley had knowledge that his license was suspended when he was driving. You will hear Officer Oliver assume Mr. Riley knew without any actual proof.
Okay, so the state calls their first witness, which, as to be expected, is Officer Oliver. She gets on the stand and walks through what happened that night.
The vehicle that I saw was traveling without headlights on. Was traveling at a speed above 45. I advised him of why he was stopped because he requested the information, and I advised him that the headlights were off.
Officer Muth arrives to the scene. What happens next?
I advised her that I believed that the defendant was under the influence, and I asked her if she would go speak with him and see if she knew the same.
So now that Officer Muth is at the scene, you have this discussion about your concerns. Does she go up to the defendant?
She does. After we determined that his license is suspended, Officer Muth begins the DUI investigation.
You found this vodka bottle. Was the defendant already placed under arrest at that point?
Yes, he was.
What was he already placed under arrest for?
Driving under the influence.
Was there another thing?
He was also placed under arrest for driving with a suspended license knowingly.
So did this vodka bottle play any decision or play any role in your decision to have him placed under arrest for driving under the influence or driving with a suspended license?
No, because it was found post his arrest. So typically when I find alcohol in a vehicle, whether it's a DUI investigation or just open container, because I dump alcohol out if I find it. He was not charged with it. So my intention of dumping it out was solely to dump it out and get it out of the car. That was it.
And then she gets into how she determined if he received notice about the suspension or not, which basically comes down to the address he gave her verbally matched the address that she looked up in the system, which also seemed to match his actual mailing address.
What did he tell you his address was?
He stated that it was 429 West Brevard Street.
Now, when you were looking at David and trying to determine whether or not he received notice of this, what was it present or available to you at that time?
It said on his driver's license that I was able to pull up through David that his address on his license was 429 West Brevard Street.
To your knowledge, Officer Oliver, was that the same as his mailing address?
To my knowledge, yes.
Here in today's courtroom, are you aware of a different mailing address?
Yes, I am. It's a P.O. box.
So here's the problem. Today is the first time that Officer Oliver is saying that these notices were actually sent to this P.O. box and not the residential address. But according to her, that's okay, because on the night of the incident, Calvin handed her a document that had his P.O. box listed as his mailing address and not the Rivard address. And so since the notices were sent there, and that's his mailing address, he obviously got notice.
Now, I want to be clear on this. When you first stopped the defendant, were you aware of that mailing address?
I was not.
Okay, so walk us through your thought process when you were trying to determine if he had received notice of the suspension.
So when I spoke to him earlier, he said that he was coming from 429 West Brevard Street. And when I saw the address as the residential address that's listed on his driver's license, typically that is the address that you are residing at. And so when he mentioned the address, along with the address being the same on David, his driving record, I assumed that he received the notice of his suspension at that address, and therefore he knew that his license was suspended.
So, to clarify, this is the document the defendant gave you.
Correct.
Officer, is this address on the document the defendant gave you the same address as the one that the notice of suspension was sent to?
Correct.
At one point, the entire body cam footage is played for the jurors. And while I'm not going to play the whole video, here is a clip between Calvin and the officers.
Don't do talking. Don't do talking. You ain't gotta read nothing. Don't do talking, man. I'm through talking. I am through talking. No, you can't read nothing. I don't want to say nothing. I don't want to say nothing to you. I don't want to say nothing to you because you're switching up three different scenarios that y'all went through since y'all started me. I don't want to talk to you about nothing. Nothing. I don't want to talk about lawyer. I don't want to talk to you about nothing. I don't want you don't even read up.
You just have to listen.
Close the door, sir. I'm asking you, please close the door. Are you recording this? Are you recording this? Well, I don't want to talk to you about nothing. I don't want to talk to you about nothing. I don't want to talk to you about nothing. I don't want to talk to you about nothing. You trying to sugarcoat it to ain't no previous nothing. I am telling you this. I don't want to talk to you about nothing, but what you said to me, miss, that you stopped me because your lights is off. And then she said she stopped me because she smelled weed. So therefore, y'all both are liars. I don't want to talk to neither one of y'all. I don't care about none of that. You can say whatever you want to say. I don't understand none of what you're saying. I don't acknowledge none of what you're saying. I am coherent with what you're saying. I have no knowledge of what you're saying. And you miss a lie. Because I don't smoke, I don't do no drugs. And what you said that you stopped me because you smell weed. My name is Calvin Everybody Senior. I'm born and raised in Tazewell, Florida. Don't close the door yet. Now, so you want to close the door now? I'm born and raised Leon County, Tazewell, Florida. I'm 55 years old, and you are a lie.
So the state wraps up their direct examination, and then attorney Desiree Goodfellow gets up to do cross. And she starts off by asking Officer Oliver about Calvin Riley's demeanor that night and how she was 100% sure that Calvin was aware of the suspension on his driver's license.
Riley's cooperative.
Correct.
He's respectful.
Correct.
He follows all your commands.
Yes.
You testified that you thought his eyes were glossy.
Correct.
He's wearing glasses. Correct?
Yes.
The day of, he was wearing glasses, correct?
Yes.
And you believe that he knew that his license was suspended.
Yes, ma'am.
When Officer Muth got there, you wanted her to ask Mr. Riley whether he still lived on the Brevard address, correct?
Correct.
And you saw that notices were sent to Mr. Riley regarding the driver's license suspension.
Yes, ma'am.
But you just assumed that was 429 West Brevard Street.
I'm sorry, can you rephrase the question?
You saw the suspensions.
Yes.
You saw that notices were sent.
Yes.
Today you testified that they were sent to a P.O. box.
Correct.
But you did a deposition, correct?
Yes, ma'am.
And in that deposition, you repeatedly said that the notices were sent to 429 West Brevard.
Because that was my knowledge, yes.
But today you're saying a different address.
Correct.
Because previously you just assumed that it was 429 West Brevard.
Yes, ma'am.
And then Desiree Goodfellow begins asking Officer Oliver many of the same questions that she asked during that deposition from video 1. Of course, this time though, it's all in front of the jury.
When you called Officer Muth for backup, that's because you already suspected DUI, correct?
Yes, ma'am.
But you weren't 100% certain it was a DUI.
No, ma'am.
In fact, at that point, you hadn't even smelled anything, correct?
I was unsure. Yes, ma'am.
Any evidence of marijuana besides a smell?
Yes, ma'am.
Before finishing the search, you went back to that 20-gram bottle that you left on the driver's seat,
Yes, ma'am.
and you picked up that bottle.
Yes, ma'am.
You opened that bottle,
Yes, ma'am.
and then you put the bottle back into the car.
Yes, ma'am.
And has that always been your testimony?
I did not know that I opened the bottle in my original testimony.
But now you know that you didn't steal it because you had the chance to watch your body-worn camera.
Yes, ma'am.
And you told Officer Muth about the bottle.
Yes, ma'am.
And you told her that because she was the primary officer,
Yes, ma'am.
because she'd be writing the report.
Yes, ma'am.
And you told her about the bottle because you were using it as evidence.
I told her that I found a bottle of vodka in the driver's seat. Now, whether she used it or not as evidence, that was up to her.
But she only knows anything about that bottle because of you.
Yes, ma'am.
An open liquor bottle found inside the car within reach of the driver would be a big indicator for a DUI, correct?
Yes, ma'am.
And you told Officer Muth that bottle was open.
No,
Has that always been your testimony?
I don't remember.
You did a deposition, correct?
I did.
You swore to tell the truth.
Yes, ma'am.
In that deposition, did you say something different?
I don't remember what I said about that.
The report says that there is an open bottle, which she knows because of you. Correct?
Maybe.
Did you not testify earlier that the only way she would have known that it was open was from you?
Either what I said or what she assumed.
And you previously testified that the only way that Officer Muth could know about an open bottle was because you told her it was open.
Overruled.
Can you
Correct?
finish your question,
That was the whole question. Do I need to say it again?
please?
You previously testified under oath that the only way Officer Muth would have known that there was an open bottle is because you would have told her that it was open.
If it was said to her, then yes, it would have been me.
And you would agree that an empty bottle would be evidence of a DUI.
Yes.
And that's an open bottle that you created.
Yes.
You're the one who made it an open bottle.
Objection asked and answered.
Overruled.
Yes.
So you're the one who created the big evidence of the DUI.
I don't know if she used it as evidence.
In the car, you also found an insulated mug, correct?
Correct.
And you claim that you smelled alcohol in the cup.
Yes, ma'am.
But you didn't test the contents of the cup.
No, ma'am.
And you didn't dump out the contents of the cup.
No, ma'am.
You just dumped out the contents of the sealed vodka bottle.
Yes, ma'am.
So Attorney Goodfellow wraps up her questioning, and then the state gets back up to do some redirect. And one of the things that they highlight is that the bottle that Officer Oliver opened, poured out, and put back into Calvin's car was never actually taken into evidence. It ended up being towed away with Calvin's car after he was taken to jail that night.
What big evidence was in this car when it was being towed?
The only evidence I know of is she mentioned the bottle of alcohol and the cup that smelled like alcohol.
Okay. Officer, was that big evidence to your decision to arrest the defendant?
No.
Okay. Let's talk about, looking aside from this alcohol bottle, let's stick to the facts. What signs of impairment led you to decide to arrest the defendant for driving under the influence?
The signs of impairment that I noticed myself was the glossy, red-shot eyes, the slurred speech, confusion when looking for documents, the way the vehicle was driving on the roadway, the swerving back and forth, the obsession speaking about the phone and other things, and then the aggression.
Now, again, just a reminder, the defense's position is that, taken into evidence or not, a police report noted the open bottle in Calvin's car, and it was implied that the cup that was found in the middle console contained alcohol from that bottle. So both of these things were used to substantiate that DUI charge and led to Calvin being arrested. So the defense says, taken into evidence or not, this still mattered. Okay, so that was day one. This trial was actually intended to just be a one-day trial, but the state says they have 2 more witnesses, so the judge adjourned for the day, and court will resume on Monday to finish this case off. But okay, now that you've gotten more insight to the charges and the case, I need you to weigh in and tell me what you think. I'll be back on Monday.